This video contains excerpts from an online workshop that the US-Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by US-Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
The authentication piece, it can be cumbersome, it can be overly formalized, but depending on the piece of evidence, for example, but the presumptive concept is that relevant evidence, whether it's testimony or a piece of physical evidence, should come in. So in other words, yes, there are some requirements for authentication, but at the end of the day, the idea is to admit relevant evidence. It doesn't matter if it's a photograph, it doesn't matter if it's a gun, it doesn't matter if it's a hat, it doesn't matter if it's a bloody shirt. If it's relevant and otherwise admissible, it should come in, even if there are some steps with respect to its authentication. Essentially, what authentication is it's just trying to document that the evidence is what it purports to be. Let's take the bank robbery hypothetical. Presumably, if you were the prosecutor in that case, you would like to show the jury what the bank looked like, just so that the jury could have a context for the evidence that they're considering. Where did this happen? What did the bank look like? Now, the jury can't go to the bank. They're in the courtroom. But the prosecution, in our hypothetical, would likely have a photograph, an 8x10 photograph, maybe blown up, of the bank. The question, based on Rule 901 is, well, is that really the bank? Is that really the way the bank appeared? So in order to get that photograph in, it needs to be authenticated as being a fair and accurate representation, in this case, photograph of the bank. Simple, right? We don't want to put in a photograph of a different bank. We don't want to put a photograph in of the way that bank appeared 30 years ago. We want the photograph of that bank as it appeared on the day of the bank robbery. And so the authentication piece, as you can see from that example, should be relatively simple, and it is. You would put the witness up who took the photograph, a police officer, say, and you would say, Officer Smith, I'm showing you this photograph. Is this a fair and accurate photograph of the bank as it appeared on the day it was robbed? Your witness says yes, photograph comes in. So I just wanted to take that very simple example to say, the authentication piece is not typically difficult, and it just satisfies that one requirement, which is that the evidence is what it purports to be. These three pieces of evidence are very different, and they require different processes of authentication, but all for the same purpose. A witness statement, real evidence, and a confession. A witness statement may likely be hearsay, and so it may not come in the first instance, but there are circumstances where it might. We won't get into them now, but the question would be, is this witness statement what it purports to be? is it in fact the statement of the witness? And so for authentication purposes, you would need, whether you were the prosecutor or the defense attorney in a criminal trial, you would need a witness who was testifying, who could say with firsthand knowledge that this is in fact the statement of this witness that was given on a certain day at a certain time. It may be the witness herself, or it may be the police officer who took the witness statement. But in either scenario, either one of those witnesses could testify that this is in fact the authentic document or the authentic statement. Take in our hypothetical number 2, the real evidence, a thing. And by real evidence, we typically mean, but not always, but we typically mean physical evidence. In our hypothetical, the physical evidence is the hat. The prosecution, if it's using the hat, would have to call a witness who could testify that this is in fact the hat that the defendant was wearing, or put differently, this is in fact the hat that was picked up on the street that the defendant dropped as he was running away from the bank. It would have to be authenticated as being the item of evidence that it purports to be. And so in example number 2, you might need 2 witnesses. You might need, for example, the eyewitness who saw the hat fall off of the suspect, of the defendant, and you would show the witness the hat, and he would say, yes, that's the hat. That appears to be the hat that I saw fall off the defendant. And then you might also have to call the police officer who actually physically recovered the hat to say, that's the hat that I picked up on the corner of 3rd and Main Street, and I put in this plastic bag, put my initials on it, typically is the way you're asked in court, and that's the hat. And it would then at that point presumptively be the thing that it purports to be, the hat that the suspect wore. Number 3, the confession. As Ira said in the last section, one of the hearsay exceptions is a defendant's prior statement. The confession would be the defendant's prior statement. So under this scenario, it would be an exception to the hearsay rule, and it could come into the trial. But before it could come in, it would need to be authenticated. Likely in that scenario, you might call the detective who interviewed the defendant. And at a certain point, after you had introduced the detective to the jury, you would ask the detective, did you meet with the defendant? Yes, I did. Did the defendant make a statement? Yes, he did. I'm now going to show you the statement/confession that the defendant made. Can you identify this? Yes, I can. What is it? It's the conversation we had written down on April 3rd, 2019, 2 hours after the bank robbery. At that point, you have authenticated the confession. It is what it purports to be. So, sort of the point I'm trying to make, I hope I'm making, is that there is an authentication requirement for evidence, but it is typically not very complicated. You just have to show that the piece of evidence is what it purports to be. But if we look at these 3 pieces of evidence, the witness statement, the real evidence, the post-arrest statement by the defendant, as we wrap up this 4th and last session, is the witness statement relevant? It is. How do we authenticate it? Well, either through the witness herself, for example, that gave the statement, or from a police officer, say in a criminal case, that may have taken the statement. And is it admissible? It's relevant, we've decided, and we know that relevant evidence is presumptively admissible, but whether or not it's admissible will depend on, to harken back to Ira's session on hearsay. Is there an exception to the hearsay rule that would allow it? The hat, number 2, real evidence, a thing. Is the hat relevant? Surely it's relevant. Under our hypothetical, the eyewitness says he saw the robber with it on, and we now know that it has the defendant's DNA on it. It's relevant. How do you authenticate it? We talked about that. You would probably call the witness, the eyewitness who saw the robber with the hat on, and you would call the police officer that recovered the hat so that it is what it purports to be. And barring anything else, it's relevant. It would be admissible. And the post-arrest statement by the defendant, as Ira said, is a hearsay exception, because even though it was an out-of-court statement, there's an exception for statements made by defendants. Is it relevant? Yes, especially if it's a confession. Is it authenticated? Not yet, but we know that's easy because we'll call the police detective who will testify that she's the one that interviewed the defendant on whatever date, and this is in fact a memorialization of what the defendant said, and it's admissible. Yes, there is an authentication requirement in the federal rules of evidence, but almost without exception, it's not terribly difficult to authenticate a piece of evidence. What is sometimes difficult is the formal aspects of doing it. You may have to line up 2 or 3 witnesses. You may have to call them in a certain order. You have to know how to navigate through the courtroom, who to go to first, and then second, and then third. But beyond that, as a theoretical matter, authentication is not that difficult.
That was great. Thank you. I just wanted to add a couple of points. On authentication, if the object is unique or somewhat unique, like the hat, it's relatively easy to put it in evidence. There are certain kinds of evidence, like drugs or money, that are not unique. So how do you put those in evidence? And we've gotten a lot of questions from our Chinese colleagues about chain of custody. And chain of custody is also not terribly difficult to prove. When the police seize drugs or money or guns, they have a procedure where it's marked at the time that it's seized, and it's placed in a secure location. And anyone who who has access to that item has to sign a log, so that there's a complete record of where that evidence has been from the time it was seized until the time it's brought to court. So most of our authentication is done through a witness who has personal knowledge of the evidence. And that having witnesses in that case makes authentication easy. This is an actual indictment of a bank robbery case from my old district in the Eastern District of New York, and added the witness statement from John Smith, and also the post-arrest statement. I want to just make a comment about the post-arrest statement, and then I'd like to show you a video. On the post-arrest statement, if the prosecutor offers it, it's not hearsay. But in this post-arrest statement, what the defendant said was he wasn't near the robbery, wasn't near the bank at the time of the robbery. He wasn't involved in the bank robbery. And as far as the hat was concerned, he said, sure, I used to have a hat like that, but I lost it a long time ago. So that's kind of what we would call an exculpatory statement. He's saying, oh, you may have my DNA on the hat, but it had to have been someone else wearing the hat at that time because I lost that hat months before the bank robbery. Now, the prosecutor might not want to put that statement in evidence because it's not particularly helpful to the prosecutor unless maybe the prosecutor has a photo of the defendant wearing that hat the day of the robbery, which could then prove that the defendant's post-arrest statement was not true and would be further evidence of guilt. We're just going to show you a demonstration from a law school class.
But in this particular case, the premise will be a Crown attorney leading real evidence through an eyewitness to a bank robbery.
Mr. Smith, where were you at 4 o'clock?
I was at the bank.
What were you doing at the bank?
I had to do some transactions. I had to cash some checks.
Did anything out of the ordinary happen while you were at the bank?
Yeah, as I was leaving, the alarm went off and I saw a man running from the bank.
What direction was the man running?
He was running away from the bank and down the road.
Was this man carrying anything?
Yeah, he had a gun in one hand and a backpack in the other.
Was this man wearing any distinguishable clothing?
Yeah, he had a white hat on with blue and gold accents. I think it was an Edmonton Oilers hat, and it fell off his head as he was running.
Mr. Smith, I'd like to show you an item.
The first step is introducing the exhibit. Here, the prosecutor has started this process by saying, I'm going to show you an item.
Mr. Smith, do you recognize that item?
Yeah, that's the hat the man was wearing when I saw him leaving the bank.
The second step is showing the exhibit. Here, the prosecutor first showed her friend, the defense counsel, what she was going to show to the witness, and then presented it to the witness.
Can you describe the hat?
Yeah, it's a white hat. It's got navy blue and gold accents, and it's got an Edmonton Oilers logo on the front.
The third step is proving the exhibit. First of all, the exhibit has to be relevant to a matter in the case, and it has to be authentic. So it has to be what it actually purports to be, and the witness must be qualified to tell the jury or the judge that it is what it is.
Your Honor, I'd like to tender this as Exhibit 1.
Is there any objection to that?
No, thank you, Your Honor.
Thank you. It can be marked as Exhibit 1.
The fourth step is marking the exhibit. Once the foundation for the exhibit has been laid by the witness, the counsel will generally approach the bench and ask that the exhibit be marked in the case. Usually it will be given a numeric exhibit number, and that will be designated by the clerk of the court or the judge.
Mr. Smith, you've indicated that you've seen the hat on a man's head. Is that man in court today?
Yes, he's sitting right there.
For the record, the witness is indicating the accused.
Thank you. That indication is noted.
The fifth step is using the exhibit. So in this case, the exhibit has been used by this witness in identifying the accused. But later on in the case, the exhibit may be referred to by other witnesses. For example, a DNA expert who matched DNA in the hat to the accused person.
An example of real evidence being tendered through a witness. It gives you the broad basics and the reasons behind each particular step that you saw. So good luck.
So that's our presentation. Our goal today was to try to introduce these fundamental concepts of evidence. Basically, as Parker mentioned, the default position is all relevant evidence is admissible. That gives us, a judge, the most flexibility in deciding what evidence should be the jury should hear or what evidence should be the basis of a decision. But then certain kinds of evidence, even if they might be relevant, are excluded either because they're not reliable, like a hearsay statement, or because of some other consideration of unfair prejudice. There are some other rules like attorney-client privilege where relevant evidence is also not admissible, but wanted to focus on the general concept that any evidence that's relevant would be admissible. The other second fundamental point is that when witnesses testify, they have to testify based on their personal knowledge. They can't testify based on what other people told them. And also, we can't use out-of-court written statements like witness statements to substitute for the live testimony of witnesses. And that's the fundamental principle of the rule against hearsay. And then the third point is that every piece of evidence has to be authenticated. And while that is a fundamental requirement, it's not difficult to